Welcome. Episode 8, Space Chums. Can you believe it? We've put 8 episodes of Lift Off, the podcast series where we lift the lid off the box called space and talk about the stuff that isn't talked about enough. We've reached it. At a velocity of 17,000 miles an hour. What a journey it's been. I'm thrilled today for our season finale to be talking about a subject which I've been itching to talk about for a long, long time. For all the series so far, we've been talking about actually quite tangible stuff. Machines, boxes, putting training in place. Today we're going to talk about intellectual property in space and how to protect it. And I'm so pleased to be joined by Phil and Chris, two eminent IP lawyers who will tell you more about themselves in a moment to start the conversation off. So welcome, buckle up, it's going to be a fun journey. Guys, welcome. Chris, Phil.
Hi,
So, your journey into space, come from different backgrounds, chatting before. Would you like to tell us a little bit about where you came from, where you are, and what you're looking forward to as well?
Absolutely. Well, first of all, thanks so much for inviting us on. I'm really keen to be talking about this topic. Obviously, it's important to me, important to Chris as well. I'm Phil. Really nice to be here. So I'm a UK and European patent attorney, but I started off in science. So I did my undergraduate in physics. Towards the end, I specialised in magnetism and condensed matter. And I really liked that, so I pushed that forward into a PhD. So I read for my PhD in condensed matter physics with a focus on the quantum side. Academia is very exciting, very interesting, but it didn't quite really scratch my itch for discovering new technologies. So I pivoted slightly and I moved into patent lawyering. So I then moved into training to become a patent attorney, which is quite standard for me, for Chris. It takes about 4 years, you pass some exams, and then you get to work in this exciting area where you talk to inventors, you learn about new technologies, and you use our scientific background, scientific education to prepare patent applications, file those patent applications, and get them granted to the various patent offices. So while my background is in quantum, I do a variety of work across different technical fields, electronics, mechanical inventions, quantum technology as well as my particular specialism. And I've recently moved into the space sector. I say recently, most of my career I've been handling space applications here and there. So I've been preparing and filing and getting granted applications for both the upstream and downstream technologies. So that's things like spacecraft launch systems, rockets, as well as software like orbit injection and control and space debris mitigation. So each of those provide unique challenges to get them granted to different patent offices around the world. And it's just been a really exciting journey to be on. And as we'll talk about, sure, this in a minute, of course, it raises really interesting questions with that interface of technology and law in space that is also really fascinating for me.
That's fascinating. Well, when you meet Chris engaging people like yourself and Phil, I could just sit back and listen because it's like rather going back into the 70s in my case and listening to your favourite sound show. But more about that later. Chris, tell us about yourself.
Yeah, well, so it's a very similar story to Phil's. A lot of patent attorneys go through a similar route. So my study started in engineering rather than science, but so I was focused on systems and control engineering in my undergraduate degree, and then went on to read for a PhD in complex system architecture design for complex engineered systems. So that was in a Rolls-Royce research centre. So the systems I was looking at were sort of gas turbine engines and the nuclear reactors.
Chunky stuff.
So, but kind of spacecraft. They're kind of the ultimate complex systems, and it's always been a passion of mine. And similar to Phil, really. At the end of my PhD, I didn't fancy a career as an academic, so I started having a look at really what offers a varied, something that uses those science and engineering skills, but offers kind of a real varied career where you get to find out about lots of different exciting technology. And as soon as I heard about the role of a patent attorney, I knew that was what I wanted to do because we get to work with exciting technology every single day. We get to be involved in the most exciting stages of all of our clients' technology development. And I don't think you'll find many patent attorneys that don't take great satisfaction in being involved and helping their clients protect protect their inventions. So since starting as a patent attorney, I've mainly focused on mechanical technologies, but it's covering a broad spectrum, so various different sectors. One of those being the space sector. And I've got a client in particular who makes equipment for spacesuits, for kind of life support systems in space, on the space station, that kind of technology, and it just gets me really excited. It's just great to be there and be involved on that journey with our clients.
And you know what? You two have picked on a really important part. Throughout the series, we've looked at broad issues, sustainability, skills, how do you market space, which was a bit of an episode in itself, because I thought that you're marketing the intangible here. But with your journeys, you're starting at a very conception point, when somebody has that bright idea on a Friday night for something, and you're seeing it and nurturing it through. We've got a lot in common, actually, because in my daytime job, apart from having fun doing this, I work with a lot of space startups, and the innovation you're seeing in areas you'd never thought about. So whether it's space gloves, whether it's articulated armor plating, etc., whether it's, I call it flypaper on the side of satellites to stop debris, but it's not all about magnetic boots and shiny suits. It's the real cool stuff. But I think a really good starting point, in the best tradition of Ladybird books of Janet and John. John, what is IP, and why is it so important?
I think it's an excellent question, because a lot of startups, a lot of companies talk about IP and intellectual property, and there's a lot of terminology, a lot of jargon or language used that some people might not find clear if they're not an expert in the area. Things like patents, copyright, trademarks, designs. What do these things mean? To take a step back, intellectual property, I suppose the clue's in the name. It's property you can own, what you do own, and that allows you to protect your intellectual creations.
An idea.
An idea conception, and you can then utilize those rights. You can sell them, enforce them in court, to basically stop other people doing what you're doing. Because the motivation behind them, or at least the story behind them, is that you've spent years, months, years, decades, maybe perfecting an idea. You spent so much time, so much money on this, and it wouldn't really be fair for someone to come along and just, you're like, I'll take that, thanks very much, and I'm going to sell it now. Intellectual property allows you to stop them and say, you can't do that without my consent. And that's the general gist. I mean, it manifests in multiple ways. And I think it's useful to understand the different types of IP.
Absolutely.
Between us and Chris, me and Chris, we can hopefully
educate away. My ears are opened and pinned back.
So in principle, there are two types of IP right. Really, there's registered and unregistered IP rights. A registered IP right is where you basically apply at an intellectual property office, a patent office, and say, here's my invention, can I have protection, please? And that can be assessed in various ways. And if you fulfill the requirements, you get a piece of paper saying you've got a registered right. Another right is an unregistered right that emerges upon creation. So you create it, you fix it, and that is yours. So the main registered right that I deal with is, and Chris as well, is patents. Another registered right is trademarks, another registered right is designs, and they all do different things. They all protect different things. So patents protect, ultimately, an invention, a technical creation that you've made. So something like a spacecraft rocket, a launch system. Even software is protected by patents. That can be technical perspective. That's different from designs, where designs create the outward appearance of a product. So, and they deliberately do not protect function. So if I have a rocket, use a rocket example, a patent might protect how the rocket works, a design will protect how the rocket looks, the kind of appeal on the outside.
And I think that's maybe something that's becoming more relevant with the commercialization of the space economy, and what things look like is maybe more of a distinguishing factor, perhaps, for people than it would have been. For example, the space shuttle was very iconic, but at the time that was created, there were very few players that could make a competing space shuttle, whereas now, with much more players in the field, its designs are potentially more important than they used to be in this sector, and trademarks as well. So protecting your branding, essentially, again, it's becoming more important with the commercialization of space.
So if I came up with an Android version of me, a physical representation, God knows how to be powered inside, you could actually protect that Android resemblance of myself.
Yeah.
In principle, yes. There's an interface between copyright and design.
Yeah, exactly.
Copyright being a creation, like a sculpture.
Yeah.
There's an interface between the two. Something protected by copyright might not be protected by designs, and vice versa. If you were to produce a production line of Bruce's,
there's an idea there, isn't there?
then the design towards that, yes, you could protect the outward appearance. But you'd also be able to get patents and trademarks for that as well.
I feel there's a separate conversation offline for this, and we'll see who does the best rate on that. And in space, do you find there are different types, though? Because space is very different. I mean, we touched on the software, we've touched on the hardware, we talk about downstream, upstream. Tell us a little bit about that side of it and how that evolves.
So in terms of the upstream side, obviously launch systems, spacecraft, some of the best ways to protect that are via, well, probably the key way to protect that is via patents. But you have also got to consider, Phil was talking earlier about unregistered rights. A way of protecting your intellectual property is to keep it as a trade secret. And that's something that traditionally would have been used, particularly say in the times of the space race, where you wouldn't want to disclose any details to anyone else, and you had strict control over the whole process of manufacturing and launching your spacecraft, and it was possible to keep many details secret, and that's something that could still be applicable, but probably less so with today's upstream sector, because there's usually multiple different commercial partners.
You buy it off the shelf nowadays, don't you?
Yeah.
It's increasingly hard to keep things secret. It is absolutely one strategy, because one of the principles of patent protection is you have to publish your technology. It's a reward for publishing. Or some people talk about it as a reward for publishing and telling the world about your invention. Yeah. So you get this 20-year term of protection once it gets granted.
20 years.
20 years, exactly. For 20 years from the date you file your patent application, you can then enforce it after grant, and it expires after 20 years. So you hear about things going off patent. At that point, you can go out and make them. But of course, by that point, the technology has probably moved on, and people have got new patents for the new improvements. So it's about keeping up to date with these improvements and developing the technology. It's why people keep applying for patents. But you have to tell the world about it.
And once you've told the world about it, you might have blocked off direct copying, but there may be a way for competitors to get around it. They've been given a clue as to how you've achieved a certain effect, and then it may give them a hint as how they can design around it, which is why people don't just file one patent, they tend to file multiple patents.
As the product development evolves. Just pick up something you just said a couple of minutes ago, trade secrets. Is the Coca-Cola recipe a trade secret?
It's one of the most famous of trade secrets, I think, that and perhaps the KFC.
7 herbs and spices.
Yeah, 7 herbs exactly, and spices, yeah. They're examples. It's often used for recipes, but anywhere where you kind of have a black box sort of technology, it could be a strategy that's worth using.
I think Coca-Cola and KFC also is notable how that has been kept a trade secret despite the massive size.
That's amazing, isn't it? It's 80 years, however long it is.
Absolutely. I mean, it's kind of kept in a safe, I think, that only 2 people have the key to. I can't remember the full story. But I mean, one thing to think about trade secrets, if you're a space company, or if you're working in something like semiconductor manufacture, you can keep that secret as long as you can keep it secret.
Exactly,
the bigger your company gets, people move in, they leave the firm, they move on to different areas. It can be tricky to necessarily be sure that these things are going to stay in health. You can absolutely take precautions, and that's a strategy you can pursue. But if you want to start talking about your technology as well, if you want to apply for funding, you want to market it, and that requires disclosing details, it becomes increasingly difficult to keep that as a trade secret. That's when patents become
absolutely.
preferable.
So for say startups or SMEs, a lot of them rely on telling people about their technology in order to get investment funding or collaboration partners that can work with them to put that technology into space. So it's not a strategy that everyone can use, which is where patents come in, because they're a really strong registered right that you can still tell people about the technology, but you're protected at the same time.
It's very interesting. So in my day job, outside of talking to great people like yourself, I work a lot with space startups, and the idea of giving them access to development tools in design and product lifecycle management. And it's interesting how far they'll go with you. You'll have your NDA in place, which NDA back of everybody has basically the same NDA at the end of the day, and there's a lot of trust and respect as well that comes into that. But getting into the nitty gritty, the dark side of what they're actually doing, we can take it so far, and then we're sort of chomping at the bit, because if you're doing a simulation of armor plating for a spaceship, we can call them spaceships, or a space vessel, etc. And how do you simulate a 17,000 mile an hour plus collision, etc. We can take it only so far, and then it's we're actually not using it. We've got a special secret source of the material. But it's very interesting when they say that. Now, IP, we understand it in a terrestrial context, and we'll try to keep it jargon-free, but we're up there, we're in space, we're whizzing around, we're in geostationary orbitry. How do we look at the territorial aspects of this? And we touched on a call before Christmas about that. But if I'm floating around in my tin can, and we'll stop at the end of that particular song lyric there, how does the intellectual property right laws on Earth translate into space?
So it's a fascinating and excellent question.
That's fine.
And we both of us.
My son asked that one, by the way.
Oh, great, fantastic. Well, compliment him for us, because I think both of us could talk about this for quite some time. In principle, yeah, you're absolutely right. Patent rights or IP rights are territorial, so each country on Earth has their own patent system.
Yep.
There are some international treaties that they all many of them, not all of them absolutely, many of them are signatories to recognise certain filing dates of other patent applications. They cooperate in some way, but ultimately they're handled by individual countries, their own courts, their own systems. So what about above the Kármán line, or however you want to define outer space?
Yes, exactly.
So there's international law discusses this, but what the Outer Space Treaty is one of those, and the seminal one, in fact, where it makes it clear that outer space is for non-appropriation by countries on Earth. So outer space is almost international waters. Some countries have tried to challenge this principle in the past, like a bunch of equatorial countries. They got together and signed what they call the Bogota Declaration, where they said, hey, okay, the area space directly above our countries, that belongs to us, thanks very much, because that's an important natural resource. And you can imagine that the USA and the Soviet Union at the time gave them quite short to this to this idea. It didn't get widespread support. And these challenges have not really been maintained. So, outer space, there's no territorial kind of ownership of outer space, so the territory of countries on Earth doesn't map into outer space. But that being said, the countries have found some creative ways people have found creative ways to interpret international law, to maybe map that onto that by saying, actually, whilst the outer space itself isn't territorial, those objects that belong in outer space actually come under the jurisdiction and control of countries on Earth. And for that reason, our patent law applies to that. So this is, rather than having an international patent system that applies to outer space, there's no space patent, there's no international patent, there are ways to say, actually, my patents on Earth do apply in outer space. And this gets into quite a technical conversation.
It's not been tested in the courts yet, but there is quite a general consensus that does apply. So, say I have a UK registered satellite, it is under the jurisdiction of the UK when it's in outer space, and it does raise some interesting issues as well. For example, it's about where the object's registered. So if it's owned by a private company, it would usually be registered in the same place that company is registered. So, for example, a satellite which is made outside of the UK, launched from outside of the UK, but owned by a UK company.
I can see where you're going on this one.
So it's never been on UK soil, but at the point where it reaches outer space, becomes under the jurisdiction of the UK, and then potentially could infringe a UK patent at that point.
Already my brain is just slightly starting to turn to jelly on this.
So just to develop that point, it's many countries, almost all countries around the world, there's still a degree of ambiguity whether this applies or not. For one country, the US, it's less ambiguous because they've promulgated their own statute. I think the Space Act of 1990. It's been around for a little while. They've written into their patent law that an object that it comes under the jurisdiction or control of the United States is considered to be made, used, and sold in the United States for the purposes of patent enforcement. So unless that object is on the registry of a foreign state, or there's some kind of specific agreement covering that object to preclude it from as such. So in principle, US patent law can apply to US registered space objects. Now, I'm not aware, and Chris, please do correct me if I'm wrong on this.
Oh, we like this, yes.
Any other
a lawyer
country,
asking a lawyer for advice here.
I'm not aware of any other country that has explicitly made this adjustment to their patent law. So when it comes to other jurisdictions, it may be a bit less clear cut. I'm not sure I would quite have consensus on the kind of say that there's agreed consensus. I mean, people make the argument absolutely from my perspective that it should apply. But the interesting thing about the UK is we have a section of the Patents Act which talks about what is in the UK. Yeah. So infringement has to take place in the UK or be offered to be put into use in the UK. I'm not going to get into the weeds of the language. We have a section saying that this also covers the Isle of Man, which is not part of the UK, but the Patents Act does include that. Also includes our territorial
There's
waters.
an element of common sense coming through here, by the way.
Well, so it could be, someone could argue that, okay, well, even though the Patents Act doesn't explicitly state it comes under the jurisdiction, that patent law applies, you can make the argument that through the Outer Space Treaty and international law, this maps on. But, the other side, lawyers, we defend our clients to the hilt, or represent our clients' interest to the hilt. If you're defending assumed infringer, you say, well, actually, no, this doesn't apply because it's not. So it's not been tested.
And I think I think it's possibly something we're going to move on to later, but the best way to counter that is, as far as possible, have your patents to cover technology kind of in its pre-launch state on the ground, where that kind of does protect your commercial interests, rather than relying on interpretation of the Outer Space Treaty.
Because it comes down to risk, doesn't it? If you're going to be suing someone and spending hundreds of thousands of pounds or millions of dollars, do you want to take the risk that someone could find that I'm trying to exercise the rights under the Outer Space Treaty in an untested area of law, or am I going to go for the manufacturing facility in the UK where I know you're making the product, and that's where I'm going to enforce my patent?
It may be that some brave company is the first to test it, and then there's a proliferation of cases after that point. But to be the first to try and rely on that is a bit of a risk.
Potentially with the emerging use of, or continued use of telecoms for space-based communication, space-based processing, we start having maybe more standard essential patents or other kinds of key patents covering space technologies that might become a bit of an appetite then if it becomes a real battleground. So we have to watch this space, I think.
I love asking what I think are naive questions or uninformed questions, but curious questions. And this one's actually from my son. He said, Dad, it's up there and it's going around, whizzing around, etc. And nobody can actually see it. So how do they know if somebody's actually infringing, somebody's copied an idea? I mean, has somebody ever asked you that question?
So I suppose it's an interesting question. Nothing goes up there without kind of it being seen by many eyes on Earth in the first place. And for a lot of technology, the patent might cover, even though it's being implemented by a satellite, which you can't see, it covers a method that has some noticeable effect on Earth. So there's definitely a need to protect your IP, even though you might not be able to see the physical satellite that it's running on. Yeah,
it's often the problem if you have to demonstrate that there's an article that you think is infringing. You have to demonstrate to the court, this is infringing, and that sometimes includes buying a copy and taking it apart and putting that in front of the judge. But if it's completely secret, it's kept secret from the moment it leaves the facility, goes to the launch pad, goes into space, and then gets shot off into outer space when it ends its life or gets burnt up. It's going to be hard. But that's assuming that's the only information you have. Yeah. I mean, as we've just talked about earlier, sometimes some companies will want to tell the world, broadly speaking, about what they are doing. This may be through the patent that's been filed, or maybe through marketing brochures, or maybe through pitch decks to investors. You can find other ways to determine what's kind of going on in the satellite, maybe. but I mean, it just doesn't mean if you're worried about competitors and what they're doing, and you're worried that you can't prove what they're doing and to enforce your patent, this doesn't mean you shouldn't apply for a patent anyway. There are many, many reasons to file for patents and other kind of IP rights that are derived from, the benefits are derived from this ability to enforce it. Basically, they are, as you touched on at the beginning, incredibly valuable. They're intangible property, but they can be very valuable. They can be worth millions of dollars, millions of pounds.
Absolutely, and you can use them as a marketing tool. If you're a startup and you've got a bright idea, but you don't have any patents, and there's another startup with a similar idea and they've got a whole portfolio of patents covering various different countries, it's going to give someone confidence that your idea is really worth investing in. And there can also even be tax advantages. So there's something called the Patent Box Corporation Tax Scheme in the UK, and many other countries have similar schemes where you pay a lower rate of corporation tax on profits from patented inventions. So even if you might not be able to successfully enforce that patent, it might be easy to show that you're deriving profits from that invention and have benefits in other ways. So.
Yeah, I mean, so some studies have shown that to develop that point, that if you have one patent, at least one trademark, you're 10 times more likely to get investors to invest in your company. Now, it's correlation, is not causation, of course. Simply by filing a patent doesn't mean you're going to have investors knocking on the door.
No, but it's a sign of the, I use the wrong word here now, but you'll understand what I'm saying, the integrity, the validity of your design.
Absolutely. Yeah, absolutely. It creates, having a patent and or a trademark or other kind of registered IP right, creates an environment that allows your company to grow. You can get more employees, you can grow as the size of your business and increase the value, which means investors are going to be very interested.
A nice question. Is it difficult to take out a patent? What are the steps?
We would both say yes, I'm sure.
Yes. Yes and no. To file an application, all you need to do is write a description of your invention and lodge it at the patent office. Right. It almost couldn't be simpler. But doing it correctly and doing it in the way you're actually going to get a granted patent, that can be difficult. That's why that's why I get paid to do my job.
And Chris as well.
It's
not pro bono.
Well, exactly. You have to formulate the application in a special way. A patent application is a combination of a legal document and a technical document. Right. You need to tell the world how you're doing your invention in a way that an expert can take your patent document, read it, and go and make it. But it has to be done in the way that a court can read it and unambiguously determine what your scope of protection is. And this is where the legal language comes in. So, in principle, talk to a patent attorney, like us, tell them about your invention, we prepare the application for you, we file it, and all being well, you'll hopefully get a grant, and you can then take advantage of all the advantages we...
I'd love the minutiae of this, and so apologies if I disappear into my own little asteroid. But is there a cooling off period where once you've registered a patent, somebody with a similar bright idea can possibly challenge it before it becomes effective?
So in Europe, there is a mechanism called you can oppose a patent, which is, and you can oppose that on the basis that it wasn't new or inventive or some other formalities that we won't go into now. But the main reason being that someone had done the same thing or something similar before. In the UK, we don't have that same system, although European patents do cover the UK. But if what they did was new and it was inventive, then if you've had a similar idea afterwards, your only options are to kind of protect what's different about your idea.
I was going to ask that,
so you might have... Patents are generally evolutionary, so they build on kind of previous technology that others have made. There are revolutionary patents, of course, but the vast majority will be evolutionary. So you can always protect improvements to someone else's patent, but you might not be free to carry out those improvements without infringing the earlier patent. So there's kind of two sides of it. There's what you can protect, and there's what you're allowed to do in view of what your competitors have protected.
And I think that's actually a really important point to make, because if startups are listening to this, I think I want to get my own patent. Remember, other people have patents as well, and they have their own protection, and you need to should be careful that you don't infringe other people's.
Well, it's like the story perhaps I've trolled this from Discovery Channel or some late night YouTube, whatever. Alexander Graham Bell didn't invent the telephone, allegedly, sorry. And the first jet engine, it was developed in So trying to, when creativity, because we're humans, we come up with the same ideas generally at the same time. You talked about the country registration of a patent. Apologies, I've got the wrong word. There's no such thing as a worldwide patent, is there?
No.
No. You can apply for what we call an international patent application, but that will never go to grant. What that is a kind of a mechanism where you can apply centrally through multiple patent offices around the world who act in a capacity as a receiving office for the international patent application. But what happens after that is you then turn that into individual national patent applications. It's a mechanism to allow people a bit of time to decide.
Yeah, sure. It buys you time, covers 197 different countries, I think. That's 193, perhaps. Yeah, sorry.
Minor detail.
Should not have gone for the exact number. No, but then after a period of about 18 months or 30 months, depending on when you filed it, you will have to decide which countries you want, and then it is on a country-by-country basis.
Which the logical question is how do you advise which country is the best country to register? Because presumably, if I'm coming with a super-duper product, selling it into one particular geography, pardon me, limits the potential revenues I could get from it. So do you, that's the type of conversation you have with customers? Sorry, clients?
all the time.
Yeah.
It's a cost-based question, as I'm sure you'll appreciate. If you want to file a patent application in the UK, US, Europe, China, etc., you're going to have to file individually in these countries. Yep. There are some mechanisms to maybe centralise or streamline this, such as in Europe, you can apply for a European patent application. But then once you get that granted, you still need to validate it in individual countries like France, Germany. Recently, there's been what's called the unitary patent, which is a European Union patent that covers some, not all, at the moment, of European Union countries, so you can get a single patent right covering multiple. But ultimately, you need to choose, and it's cost. How much can I afford to pay with my budget? And we would typically advise them, okay, where are your markets? Where would you want to be able to enforce this patent? Where are your competitors working? And that's the normal advice we kind of give for any business. But space, that is a bit more of a unique question because it depends on what you're doing.
Yeah, absolutely. It's technology dependent.
Yeah.
Because if you're obviously, there's a place where your invention might be manufactured, where it might be launched from, where kind of ground-based communications might be based. If your kind of invention is around how a satellite is controlled from the ground, where that might be taking place, which countries have the infrastructure to carry out that kind of technology, and perhaps even where it might be landed if it's a returning spacecraft. So it depends what you've invented and where it's going to be implemented.
And there's a really, I think, quite important point to pick up on that when it comes to, as you mentioned, where spacecraft is launched from. There are some countries that include within their patent law, but most countries include within their patent law, this exception for temporary presence. So what this means is if, for example, take the example of an aircraft. I fly my aircraft from the US, land in the UK temporarily, take off and go back to the US. If I've got a UK patent, then there's defense for patent infringement to say, well, my aircraft was only temporarily in the UK and it's gone back to the US. You can't enforce that. Now, the legislation doesn't explicitly state spacecraft in the UK as being a vehicle or qualifying for this temporary presence, but in the US it does, and I believe also in France.
Yeah, in France as well.
So if there's a spacecraft that's been manufactured in the UK, shipped over to the US, and launched from the US, and then is on the UK launch register, my understanding is, under the US patent law, very difficult, not possible, to be able to enforce. Depends on the conditions in which it's imported and other kind of things I understand. But if it qualifies as temporary presence, you won't be able to enforce that. So you have to think, well, where are my competitors launching from? Where are their objects registered? It can get quite tricky. That's if you want to enforce the launch, the use of, if you want to make the argument that the objects are used by launching from the US. So that's an important point to clarify. So you want to be thinking, okay, which country do we think is going to be the launching state, which is the one has the jurisdiction control. That's probably where you want to be protecting. Because as Chris kind of mentioned earlier, the main route to protection, the most robust route to protection, is to kind of enforce on the earth where it's being made, where it's being sold, that kind of thing. But if you've got a technology, so for example, I'm making drugs in space, or I'm making semiconductors in space, and the patent is kind of covering what's happening in space, the actual method of manufacture, then you might need to think about, okay, well, I need to rely on these.
Which is an interesting point there, because let's say you are developing a micropharmacy machine, a mini chemistry sets, etc. And we know there are a number of emerging companies who are leading this trend on that. So the hard work would have taken place at Cranfield or another centre of excellence, etc. But it's actually doing its magic, and pardon my language, it's doing its magic up in space, isn't it? Does it? So we're talking about inheriting the legal framework, the IP, from the country of its development, and that then applies to that little black box. Is that right?
Well, yeah. As far as possible with something like that, as we said before, you wouldn't want to have to rely on the Outer Space Treaty. So you'd want to try and claim, cover with your patent a satellite which is configured to manufacture this pharmaceutical compound, because that would then infringe a patent while it's on Earth, while it's not actually in the process of making that.
Yep.
It's that the apparatus is configured to do that. But that isn't all. As Phil said earlier, it's not always possible.
Because I mean, if the patent is towards a drug that's been made, or a product that's been made from a result of that process, then you could enforce that patent for a sale of the object when it gets put on Earth. Whether it counts as an import into the country of landing countries is a completely different question, and I understand still under development what counts as import and that kind of thing. But that's one way to protect it. You have the apparatus that makes it, or you can try to rely on statute, or the application of national law to space to stop people doing the method.
Can we talk about collaboration now? Because increasingly, unless you're a superpower, that's an anachronistic phrase, because decline and fall of various empires at some point, increasingly companies and countries are coming together. So let's take up what's up there in the ISS, etc. How do you look at it, pardon me, where countries have collaborated, individuals have collaborated on a particular idea and come up with a new thing?
So I think normally so the UK doesn't own intellectual property that's created by its citizens. Its employers is it's either the inventors themselves, or if they're employed in a capacity where it's expected.
Is that clause in your employment contracts? If you have any bright ideas, the company owns it.
Yeah, but even without that clause in the contract, the UK Patents Act means that your employer owns your inventions, and similar laws apply in most of the world. So I guess in the context you were talking about with this collaboration between, it would be who their employers are and what agreements they have in place around who owns the IP. Yeah,
it's the first thing you check when someone approaches you for a patent application. You say, who are the inventors? Where do they work? What's their nationality? Because that has an impact on who actually owns that IP. Yep. But I mean, I think there's another avenue to this question of legal systems talking about national security provisions, or for example, in the US, you've got the ITAR and the AR provisions, which put some restrictions on the export of technology and arms and so on. And patentable technologies and patent innovations do come under that. So if you have one country, inventors working in one country, and inventors are working in another country, then both countries' laws can kind of apply to the creation of that invention, and they may put stipulations on where you file your patent application and what you can do. So you might end up in a situation where you've got one inventor in the US, one inventor in Russia, and both of them have laws, and they say that you have to file first or get permission from international. You have to get permission from their respective patent offices. And that's a question of applying foreign filing licenses or whatever. So it's a really important question you raised, like collaboration. You need to think about what are my obligations to fulfill requirements under national law. But it comes also down to ownership, because you have two inventors of different companies, and they each own part of the patent, an equal and undivided share, at least in the UK, which means that they both have the right to exercise the invention. So if I'm a startup and I talk to some company maybe in the US, and we each own half of the invention under default considerations because we both contributed towards it, and suddenly I've got this company in the US owning half my innovation, even if they've only contributed maybe a small part to it, but if they've contributed towards the creation of that. So it can put you maybe in a bit of a bind later on, depending how good your relationship is with this company.
Yeah. But generally, we'd always try to advise clients to kind of make clear via collaboration agreements before they get involved.
So you actually quantify the extent of the collaboration.
So, well, you can have a collaboration agreement which says which says that all IP will be owned by one of the particular partners, and that is particularly important if you plan to sell or license your technology. So say you're a startup, you've got your invention, but you don't have the resources to put it into effect yourself. You might want to license your patent to a larger company, but they when you're joint owners, you can only do that if both parties agree. So you could end up in the situation where one party sort of holds you to ransom, and so it's a situation we'd always try to avoid if possible.
Yeah, you can stipulate if you work with a company, say we own the IP, but you can ameliorate that with your colleagues by saying, look, we'll grant you a license to use it, and you can find, or we'll give you royalties or some way. So it's always recommended that if you feel like you've created that invention and that's yours, and you've brought in help to partly develop it, but you really want to control the IP, get that agreement in place from the outset, get them to sign it, and then you should be free to work on that.
Stuff comes along in trends and waves. I mean, to trivialise it, but not too much, but fashion, for example. Yeah. Somebody comes up with a new sweater, and my other half will be looking at a dozen examples within a couple of weeks being copied. Do you see trends in IP just because of the joyful creative process that humans come up with the same idea at the same time in different parts of the world? Is that something you come across?
I mean, there's the general trend in patent filings anyway for space technology has been a big increase, and a big part of that's been driven by an increase of filings in China.
Okay.
But that isn't limited just to space technology actually. So a few years ago, China introduced some incentives to get more Chinese companies to file patent applications. Right. And I think I saw a report from the EPO saying that over 50% of patent applications in cosmonautic space technology were being filed by Chinese companies. So that's been a big driver. But even taking China out of consideration, there's been a big increase. And another huge area of increase has been in kind of green kind of space-based sensor technologies. Okay. So that's been I think that was one of the top 5 areas of growth in patent filing numbers over the last decades. Technology growth actually mirrors also societal concerns as well.
Absolutely, yeah. I mean that's across a variety of technology fields as well. Cosmonautics, the spaceborne sensing, as the propulsion systems, as well as more and more launch providers are coming online. China's also leading the way on that. Yep. I think it's for propulsion, at least in 2022, I think it was 65% of filings, and over the last 20 years, I think 36% of filings. Absolutely huge, and that should be contextualized actually by kind of what Chris was commenting, that there have been recent incentives. There's been a national policy goal in China for over a period of a decade to file more domestic patent applications. Companies get rewarded with funding, job offers, and they're all kind of all domestic filings, really. Well, 5% of them, I think, are international filings. They keep them domestic, they don't pursue them internationally. That could be due to budgetary constraints or
just stashing them away for a rainy day.
Potentially. Well, the quality of the application is also something to be commented on, because you could be naively thinking they're just filing something to get the funding, get the job offers. But also from the same reports that kind of Chris mentioned, the EPO have done some fantastic reports on this, providing some data. They've commented that since 2007, 2008, the cross citations for Chinese patents has been rising quite significantly. So previous to that, you typically, when you file a patent application, it gets examined, and the patent office will cite other patents against it to kind of try to say, you need to clarify your scope. Previous to 2007, it's mostly US, Japanese documents. But since 2007, a lot more Chinese documents have been cited. And that doesn't happen unless there's something real substantive in there. So I think this surge in Chinese filings is quite indicative, or it's kind of evidence of what we're seeing elsewhere, of a huge investment by the Chinese in the space sector. and they are really doing quite a lot. I think after SpaceX, I think they're the highest number of launch attempts.
And the space race is it's still hurtling out at great space. Again, another question from my son, and it's been very interesting. He understands the idea of registering a patent. Pardon me. It's like
it's patent or patent.
Patent
I mean, to be honest, like everyone I know says patent, but also patent's fine.
But I say tomato, you say tomato. Let's call the whole thing off. You're registering in the country. Let's keep it nice and simple. In the country where you work, where you reside, etc., and it's going to go up from there. So the three of us are in the ISS now, and Russians, pardon me, the Chinese, and the Americans, etc. Here. My lab dies on me. All my tech dies on me. It's for some technical reason. The ISS is approaching into its lifespan, so I have to go into Phil's section of the space station, which technically is it's the Russian zone. If I come up with a brilliant idea and have used some of the kit you've got, but it's actually on Russian territory, is it a Russian invention or is it a British one or American one? So.
It's not so much whether it's a Russian invention.
Yeah.
The question is that you've created it. So it's your invention.
Right.
So, but when you go into a different module on the International Space Station, then my understanding of there's an intergovernmental agreement the ISS has put in. It's quite interesting that is one of the few, in fact, maybe one of the only, I'm not quite sure, it mentions intellectual property quite specifically. And it says on different modules, the national kind of law will apply. So if you're working on an invention in the US module, then US territory, you're basically equivalent to being under the jurisdictional control of the US.
Yep.
Same in the Russian module and the Japanese module. I don't think there's a Chinese module on the space station.
Not on the
Not on the ISS.
We'll change nationality, don't
But
worry.
yeah, exactly. But I know, my understanding of the treaty, I'd need to look at it again in more detail, but if you were to kind of create it in a different module, then that national provisions would apply, and then you think, okay, well, it's taking place in Russia, and that security provisions might apply there. So it's a really interesting question. I'm not aware of it being tested.
It's also, some of these questions can be a bit theoretical in that
until it happens.
Until it happens. Yeah. But in that generally, things like that may happen, but there's kind of quite a good relationship between astronauts of different nations on the International Space Station, and how there's not many people there, and it's not all visible. So to what extent it would be easy to actually enforce any, say, infringements of IP that happen on the space station is
I mean, it's once you get to the stage where you've got a mission approved, budgetary sign-off, going into the ISS, there's going to be a certain degree of collaboration there between nation states, and is everyone going to have the appetite? Is there going to be a commercial benefit?
Does common sense apply sometimes?
To a certain extent. Why going to go after these people if there's a lot of money on litigation? And most stuff going on the ISS is kind of research rather than commercial based. But the ISS agreement, I think, is quite an interesting one to bring up because it's one of the areas I'm aware of where European countries, IP law can explicitly apply.
Yep.
So this kind of goes back to our conversation near the start of, does the UK Patent Act apply in space? Well, it can apply on the ISS because the ESA module, it says that any one of the member states of the ESA could deem their patent law to apply on that ESA module.
And with the ever-expanding commercialization of space, and we won't mention people by name because it's not fair, is it? But do you see that complicating things, or are we going to see the big space corporations? And I'm not thinking of the Wayland Hunani of the world, etc. But the Bezoses, the Musks, etc. Are they going to become increasingly protective? You think of the stuff they're doing?
So, as there's a lot more competition, there's a lot more commercialization. Inevitably, into any technology field where that happens, there tends to be kind of a proliferation of patent filings, particularly as it becomes a more established and mature market, because everyone's trying to protect their little slice of that market. And the big players, but also the small players, will all have an incentive to protect their market share. So
I mean, the majority of patent filings in this space that I understand are still originating from the primes. So your big launch providers and your big service providers. SpaceX is an interesting one. because Elon Musk has previously kind of made the pronouncement that patents are for the weak. I don't patent anything. They do file patents.
Yeah. They're quite useful.
Well, exactly. I mean, I think over 200 patents in the last 5 or 10 years they've filed.
One of the biggest filers of
the space technology patents. So I think he would make the argument that we only file kind of essential core stuff, but that's what most people do anyway. I mean, some companies will throw everything in a wall and see what sticks. They have a huge patent budget and they decide, right, this small improvement, I'm going to try and patent that. If I don't get it granted, I don't get it granted. I'm going to try. Some people focus on these core improvements. So I don't know what's going on in the mind of Elon Musk or in SpaceX, but they certainly have been filing. And this is maybe indicative they view the value of patent applications. Same Blue Origin are being filing patent applications as well.
An interesting question. We had, at the very beginning of the series, we had Chris Whitehorn from the UKSA. Does the government file patents?
Not very many, I don't think.
I'm not certainly in the space sector. I mean, you can kind of
because the government research establishments must come up with brilliant ideas for new tech, etc.
Yeah, I mean, I think different departments, can be co-owners on patent applications. I've certainly seen that.
So it's a bit of a curveball for you guys. Sorry.
Yeah, no, it's not really something that I don't have any clients. I'm aware in the government.
But I think often the government will work with a commercial partner to commercialise inventions, and that's kind of the place where collaboration agreements might be in place from the start, so that the commercial partner gets the opportunity to commercialise that technology whilst still kind of achieving the goal of the government in creating the technology.
And in fact, even in the comparatively short time I'm working with companies in this sector, you do actually see a very, how to describe it, open-minded and supportive view from organisations like the UKSA. So they'll provide funding, etc., mentoring, and they make quite clear at the beginning of that engagement, the IP is with the inventor. They're the nurturer.
Yeah, so the incentive of the government is to nurture more innovation in space, but the intention isn't for them to commercialise that themselves. It is for us to have, for our economy to benefit from a well-functioning kind of private space economy.
So here's an interesting question. Again, it's just come from organically out of this conversation. You've both been doing this for some time. You're both very passionate about it, which is really nice. And the flow of the conversation, this is one of my most fun episodes. Do you have a favourite invention?
Oh, crikey.
Oh, it's a difficult one.
There's some inventions that I have enjoyed working on with some clients, and I mean, to a certain extent, I'm restricted from giving too much detail.
That's
on
fine.
But I mean, just into the broad technical field. I mean, I really enjoy quantum technologies, for example. I work with some clients that are really on the cutting edge of the field, and a lot of the kind of language, a lot of the terminology is still kind of under development. So kind of preparing the patent application, nailing down the inventive concept and understanding what's going on, working with the inventors is a real pleasure, because you sit down with these kind of very educated, very clever people, and you're playing catch up almost. Like you say, okay, you've come up with this new idea. How does it work? What's going on? And you delve into the physics, and it's really, really interesting. There's a reason I did the PhD. I mean, I didn't like the overall kind of career structure, obviously, but like it's really quite exciting. I mean, in terms of the space stuff, I mean, I've had a couple of patent applications I've worked on that have been really kind of quite interesting to work on. A couple on space debris mitigation in particular has been a real. I enjoyed the challenge because it comes down to software, and what can and cannot be protected in software will depend on the extent to which you can argue a software has a technical effect, and trying to argue that before the patent office.
That's how do you copyright noughts and zeros is the question.
Yes. Well, yes.
Noughts and ones, pardon me.
Well, quite. It's a whole conversation about software. We can
Series 2, everybody.
Yeah, I'll pass over to Chris to talk about his favourites.
Yeah, so, I mean, on a personal level, I always love working on inventions that I then can actually see. So I do quite a bit of automotive work, and whenever I see particular vehicles driving past, I know some very intricate details about perhaps a mounting bracket on the bottom.
Yes.
It's that kind of thing. And I like the everyday inventions that maybe go a bit unnoticed.
Oh yeah, no, this can be good. Yeah. Someone's come up with a new hairbrush or a new.
Absolutely. As a parent to young kids, and there's all sorts of gizmos and things that they've got, which and very often you just kind of turn over and look, and there's a patent number, and I find myself Googling it and looking at kind of what's been protected.
So you must look for the world through a slightly different set of goggles to everybody else, you know.
Absolutely, yeah, I think we do.
Absolutely. You kind of look at, well, especially when it comes to like news stories online, they'll say, this company has patented this product, and if you're like me, you go and check the patent out, and you realise, okay, that's a patent application, not a patent to begin with, so a bit naughty. You shouldn't be saying you patented something when you haven't. But also it's good to look at the detail. Oh, that's how it works. That's really interesting.
Yeah. You must have the most inquisitive minds we've come across on this series. It has been an absolute pleasure to talk to you both. Sadly, with all great journeys, we have to come to an end. And so with that, we've come to the end of season 1 of Liftoff. I'd like to thank all the guests who've taken part in it. We look back over it, we've had 24 people, we've had 110 questions asked, but each one has been an absolute gem and nugget. As they say, all best series, like and subscribe. Please register on our landing page. We're having a small competition, which is to help companies accelerate their own product development. So please put your details in on the like and subscribe page. We'll be pulling out a winner for Series 2. But on behalf of Technia and everybody, Phil, Chris, taking part in a fantastic series, goodbye and see you in Series 2.
Thanks so much, Bruce.
Thanks, Bruce.
Thank you.